Hi, warriors. This is Jaylyn, my legal warrior, and today's segment is about best interest of the children. This term is a legal terminology. Best interest of the children could sometimes be a very subjective term, because when you hear best interest of the children, what do you actually understand from that phrase? The term speaks for itself. Best interest of the children. So what is in the best interest of the children? According to whom? Well, in California, it's going to be according to the Family Code Section 3011, and the judge has the discretion to make orders that's in the best interest of the children. Now, if you don't want the judge to be making decisions on behalf of your family as to custody and visitation, then you can settle with the other party as to what a good visitation schedule between you and them could look like. And maybe you and the other party are in agreement on some aspects of custody and visitation, but there's just a few issues here and there, such as vacations, for example, or out of county travel. Those sort of issues, you and the other party are in dispute and need the assistance of the judge to make an order as to what is in the best interest of the children. So we're going to take a moment to review Family Code Section 3011 and how the court describes the best interest of the children. So this is Family Code 3011, and in making a determination of the best interests of the child in a proceeding, the court shall, among many other factors, find relevant and consistent with Section 3020, consider all of the following: the health, safety, and welfare of the child, any history of abuse by one parent or any other person seeking custody against any of the following: a child to whom the parent or person seeking custody is related by blood or affinity, or within whom the parent or person seeking custody has had a caretaking relationship, no matter how temporary. Think of grandparents. The other parent. A parent, current spouse, a cohabitant of the parent or person seeking custody, or a person with whom the parent or person seeking custody has a dating or engagement relationship. As a prerequisite to considering allegations of abuse, the court may require independent corroboration. So not just your word that the child has been abused, or the other party's allegations that the child has been abused, or even the child's allegations that he or she has been abused. So the court can look at written reports by law enforcement agencies, child protective services or other social welfare services, courts, medical facilities, or other public agencies or private nonprofit organizations providing services to victims of sexual assault or domestic violence. Abuse against a child means child abuse and neglect. Abuse against any other persons that are described in this clause or subparagraph A means abuse as defined in Section 6203. The nature and amount of contact with both parents, except as provided in Family Code Section 3046. The court will also look the habitual or continual illegal abuse or use of controlled substances, the habitual or continual abuse of alcohol, or the habitual or continual abuse of prescribed controlled substances by either parent. Before considering these allegations, the court must first require independent corroboration, including but not limited to written reports by law enforcement, courts, probation departments, social welfare agencies, medical facilities, rehab facilities, or other public agencies or nonprofit organizations providing drug or alcohol abuse services. Controlled substances are going to be defined under the California Uniform Controlled Substances Act and the Health and Safety Code. And you can review a separate video as to how the court views legal controlled substances, for example, marijuana. Now, when allegations about a parent have been brought to the attention of the court in the current proceeding, and the court makes an order for sole or joint custody to the parent, the court has to state, so they are mandated to state, its reasons in writing or on the records. So in these circumstances, the court shall ensure that any order regarding custody or visitation as to a specific time, date, place, or manner of transfer of the children is going to be set forth in Family Code section 6323. And that's supervised visitations. Now, this paragraph is not going to apply if the parties stipulate or agree in writing or on the record regarding custody and visitation. So again, if you and the other party have an agreement and negotiate a settlement as to custody and visitation, then the court will enter that stipulation or that agreement as its court order. But it has to be within the best interest of the child. So if the court reads it and does not believe that's in the best interest of the child, the court may make modifications. Notwithstanding subdivision A, the court is not going to consider sex, gender identity, gender expression, or sexual orientation of a parent, legal guardian, or relative in determining the best interests of the child. So Family Code section 3011 is imperative to any child custody and visitation case. If you don't know what the court is going to be looking for when you attend your child custody and visitation hearing, or when you even check off the box for the court to make child custody and visitation hearings, then the Family Code section 3011 is a really great starting point. Please share this video if you found it to be helpful, informative, if you know anybody that might benefit from this accurate information from My Legal Warrior. There's a lot of misinformation out there in the public, and this is supposed to help correct that misinformation. Thank you, warriors, and we hope that you are doing well and you are safe during this quarantine.